Yeah.
What we have is basically a deck action from Builders Insurance saying, Judge, will you please declare, if it's in favor of Builders Insurance, we don't need to indemnify Mark Anthony Holmes and or Mr. Ferguson at all. And maybe if we have to, it might be limited to some damage to some soffit above the garage. And we'll dive into the details. But that's what this fight is about. It's not about the arbitration. It's not about the house. It's, does Builders Insurance need to cover the nearly $300,000 that the arbitrator awarded Mr. Kamara? And Builders Insurance says no, because all these claims flow from what Mr. Kamara has characterized as bad workmanship, poor work by Mark Anthony Holmes. And that's not what the insurance is for. The insurance is for damage to property because of what we call an occurrence. Maybe if one of the pieces of equipment that Mark Anthony Holmes was using shot a rock out the side and it shattered the window of a neighbor's house, Builders Insurance would cover that. And there are many other examples of what Builders Insurance believes they ought to cover. But something they argue they don't need to cover would be poor workmanship. That is a matter for Mark Anthony Holmes and Mr. Kamara to work out. And lo and behold, they did, and they had an arbitration. Mr. Kamara likes to disagree and says, nope, you are liable, Builders Insurance, for all of this, because otherwise they're public policy arguments. And I'm going to let Ms. Jackson give full voice to Mr. Kamara's concerns. But I think that's where we are in terms of what the dispute is. And more specifically, Builders Insurance is seeking summary judgment. Judge, please, at this juncture, because it's really just applying a contract, an insurance contract, we, Builders Insurance, believe you ought to grant us summary judgment, case closed, declare that we do not need to indemnify Mark Anthony Holmes or Mr. Ferguson for any of the arbitration award. Ms. Woodrick, tell me what you'd like to add to that in terms of providing a setting for what then I'll let you and Ms. Jackson argue about.
Yes, Your Honor, I think you hit the nail on the head with your description of what's at issue here and what's at stake here. What I would like to add is the matter of the indispensable or necessary parties under OCGA 91119. There was a brief mention of that in the response in opposition from Mr. Kamara, and a footnote that a motion to dismiss would be filed at some point. To briefly address that, as shown in our reply and Builder's reply, the insured and its principal, MAH is what I'm going to refer to Mark Anthony Holmes as I go through. MAH and Mr. Ferguson were originally parties to this action, and they have been fully apprised of the coverage issues and what Builder seeks to do with this declaratory judgment action, and they have agreed to be bound by this decision. So because of that agreement, there's no concern about there being inconsistent obligations down the road, successive litigation, and there's really no concern about their rights being prejudiced in the sense that they are aware of what has gone on here and they've made a decision to be bound by what this court decides regardless of their participation in it, and they chose not to make their own arguments as to why the claim should be covered in this case. So to the extent that a motion to dismiss would be filed down the road, we could address it further. But at this point, we still think that summary judgment is appropriate in the sense that all the parties that need to be involved are involved in this case.
So Ms. Woodrick, is there, I'm opening up the docket right now while we're talking. Yes. Is there something in the docket that reflects what you say MAH and Mr. Ferguson have agreed to? In other words, we don't need to be in this fight, and we will be bound by it, so that poor Mr. Kamara doesn't have to engage in further litigation, because Mark Anthony Holmes then may say, well, no one asked us what we thought about coverage, and we certainly think Builders Insurance should cover us for this. It's a lot of money, and we want them to pay up. Is there something in the docket?
Yes, Your Honor. In the reply in support of the motion for summary judgment, attached to the reply as Exhibit A is the letter from Builders Council to Mark Anthony Holmes, which Mark Anthony Holmes and Mr. Ferguson then signed to memorialize their agreement.
This is what was filed just a couple days ago?
Yes, Your Honor.
Okay.
Judge, if I can respond to that whenever you're ready, I just wanted to let you know.
Of course. I just wanted to know what's in there, because that will shape in part my response to the concern. So there is. Okay, I see. So Mr. Atkinson drafted a letter, and Mr. Ferguson's signature for both himself and as a member of MAH. Okay.
Yes,
yes, Ms. Jackson, I certainly do want to hear from you about this issue of who ought to be involved in this discussion.
Yeah, and as you pointed out, Judge, this reply brief was filed 2 days ago. And it looks like the date on the letter is January of 2020. So it's our position that the letter shouldn't be considered on this motion for summary judgment and should be stricken from the record. There are a couple issues that we'd like to bring up as far as this letter. First, it's not authenticated. Neither Mark Ferguson or Mark Anthony Holmes are here to authenticate their signature. According to the plaintiff, this was signed in January. So we've had 8 months to get some sort of affidavit from Mark Ferguson or Mark Anthony authenticating their signatures and approval of this agreement. And I'd like to point the court to DirecTV LLC versus White. The site is 844 SE 2D289, where the Court of Appeals held unauthenticated documents containing inadmissible hearsay cannot be considered on summary judgment. In that case, the plaintiff sought to introduce insurance letters as evidence on summary judgment. However, while one was unsigned, the other document was signed by an individual that did not provide an affidavit nor deposition testimony indicating the source of the information of the letter. So the court held that the letters were not authenticated properly and could not be considered on summary judgment. And as the court pointed out, obviously there's nothing in the docket until 2 days ago. So it's the first we've seen this document. And additionally, the judge's staff attorney sent a email out and asked for all exhibits to be presented by Monday, September 14th. And this was filed on the 16th, I believe. So in addition to failing to follow the court's order, or at least the email from Ms. Niles, the plaintiff has failed to authenticate this document, and we just believe it should be struck from the record.
Okay, but say for a moment that it's struck from the, what does it have to do with the summary judgment piece?
Well, so we believe that this motion for summary judgment isn't quite ready because those two parties are necessary and indispensable. So Mark Ferguson and Mark Anthony Holmes, the plaintiff pointed out that they've agreed and they wrote this letter and signed it, but it doesn't necessarily, again, because it's not authenticated and it wasn't presented to the court in a proper manner, Mark Ferguson and Mark Anthony Holmes may still be on the hook regardless of what the court decides. And when they initially filed this deck action, the two were parties. And then they just sort of dismissed them, I assume, based off of this letter. But again, we weren't aware of that until 2 days ago. And based on OCGA 91119 for the joinder parties, If a person is feasible to be joined, which again, they were parties from the beginning, they're a Georgia company, they have interest in this matter, they should be a party to this matter. And that kind of goes back to my argument about the letter not being authenticated. We believe they're indispensable and necessary parties to the case, meaning we can't go forward on the motion for summary judgment.
Okay. Anything you want to say in response to that, Ms. Woodrick? The timing is a little peculiar. Your colleague authored the letter last year. It's a December 31 letter. The signatures were affixed early this year. And it looks like then the timeline was a couple of weeks after that is when Builders Insurance filed the dismissal without prejudice for Mark Anthony Holmes and Mark Ferguson. So that all makes sense. They signed off saying, great, we're okay with that. You'll drop us from this lawsuit. We agree to be bound by it. And lo and behold, your client moves to dismiss those two defendants. Any particular reason why at the 11th and a half hour now this letter pops up?
Your Honor, I will say that I cannot speak to what happened in January or really up until I entered my appearance this summer. So I'm not privy to why the decision was made not to file that specific letter or some other affidavit showing that Mark Anthony Holmes and Mr. Ferguson would be bound by this agreement. However, I will say that to the extent that there is a concern that the letter is insufficient and that summary judgment shouldn't go forward because the letter is insufficient, builders would be happy to have Mr. Ferguson on his own behalf and on behalf of MAH provide something that is notarized, an affidavit, something that memorializes that in a more formal way if that is what the court requires and what the statute requires. I believe that it was not filed previous to the filing of our reply brief because we were not aware that it was an issue or that there would be an allegation that the indispensable parties were not involved. To that point, Mr. Ferguson and MAH were, as you noted, dismissed many, many months ago, and the issue of whether they were necessary and indispensable parties did not arise until this response in opposition. So that was our first indication that proof needed to be filed, but we are more than happy to supplement that with something more formal if that is what the court would require. Okay.
Here's how I'm going to rule on Ms. Jackson's objection. I'm going to deny it. First of all, the authenticity of a written document is subject initially to the court's assessment of, is it what it claims to be? Ultimately, it would be the fact finder who would decide how much weight to give it. In looking through the docket while we've been talking, I found a number of records with Mark Ferguson's signature on them. These would be records submitted by defendant. These would be records submitted by plaintiff. And in my lay opinion, that's the same signature. It's the same Mark Ferguson. It has a very distinctive F to the Ferguson. And I'm looking, for example, at one of the exhibits attached to the petition, which was, let me get back to the top of it, probably the contract under which Mr. Kamara, the construction agreement, which starts at page 56 of the 367 pages of the petition, because it has a number of attachments. So one, I think it is what it says it is, which is Mr. Ferguson's signature on a letter authored by counsel for plaintiff. Two, in terms of the timing, I will note that the plaintiff in this case on January 14th of this year, so 8 months ago, dismissed Mr. Ferguson and Mark Anthony Holmes, and nothing was said by defendant Kamara for months. There was no pleading filed asking the court to deny that dismissal or to countermand it or to do anything that would bring Mark Anthony Holmes and Mark Ferguson back into the mix. So Mr. Kamara has been on notice for 8 months that this was a deck action between Builders Insurance and Mr. Kamara and no one else. I think the time to bring up a concern about that would have been within 30 days of that dismissal being filed. Doesn't mean it's not a ground for defendant to oppose the requested relief of summary judgment. But I do find that the letter that is attached to plaintiff's brief filed a couple days ago, while new to all of us, the letter's not new, and it was the form and substance that prompted plaintiff Builders Insurance to file the dismissal of Mark Anthony Holmes and Mark Ferguson. So actually not a new matter. And if we were going to work through the indispensable nature of those two parties, it should have been long before now. But your objection was made and is preserved. And I'm going to give the letter the weight I think it's due, which is an apparent signature of Mr. Ferguson, making clear to Builders Insurance that he individually and Mark Anthony Holmes as a corporate entity were prepared to be bound by whatever coverage ruling flowed from this declaratory judgment action. All right, having tackled that, Ms. Jackson, anything else you want to talk about, just sort of laying the setting so that we can get into the substance of the motion for summary judgment?
I think you put us in the right setting. You said everything I would have said as our brief little fact intro.
Okay.
I think saved us a lot of time. So
Excellent.
I'm sure we both appreciate it.
All right.
Absolutely.
What I'd like to do is sort of flip this around. I know that the burden is on Ms. Woodrick on behalf of the movement for summary judgment, but in looking at the motion and the response and all the attachments, I'd like to start. I'll be more informed by having Ms. Jackson articulate why she thinks that the award and the substance of the claim that was granted in the arbitration doesn't fall squarely within the exclusions that Builders Insurance is relying on and is asking this court to enforce. Because as I read it, this doesn't seem like a real complicated question. But I am not a builder, and I'm not a contractor, and I'm not Mr. Kamara. And so, Ms. Jackson, you may have some nuances that you want to share with me to help me understand. And you're free to give voice to the public policy argument as well. That one, I hear you. I don't know that that carries the day, but setting aside the public policy argument, the types of things that Mr. Kamara was successful in getting from the arbitrator seem to be the types of things that Builders Insurance, in no uncertain terms, said, that's not what we're covering.
Okay. If I could start with just summary judgment standard.
Mm-hmm.
So we cited the case Sawhorse in our brief, and obviously, as the court knows, there's an extremely high burden on behalf of builders in this motion. Insurance policies should already be construed against the insurer. And as the court knows, the facts must be viewed in light of the non-moving party, my client, and any inferences in favor of my client. So first, the plaintiff discusses our initial complaint based on poor workmanship and how that's not covered. And as you mentioned at the beginning about the garage soffit, which I was not very sure what it was because I'm also not a builder after Googling a few things. It's the little lip on the garage. Yeah, that's pretty much what Google Images gave me. And so Builders argues that the damage to the soffit, we would argue that the damage to the soffit is property damage caused by an occurrence, which that phrase is used throughout both of our briefs, within the meaning of Builders policy, or the issue of coverage should at least be a question of fact to be presented to a jury and not decided in summary judgment. So the claim of poor workmanship here and in the evidence in our deposition testimony and in arbitration from our expert shows that the soffit above the left and right garage portals were damaged by an excessive supporting wall, the movement of an excessive supporting wall. So builder's policies defines property damage as physical injury to tangible property. And case law cited in our brief, Maxim versus Jimenez, makes it clear that property damage contemplated by commercial general liability policies is that damage caused by faultily completed work causing damage to property. According to both the policy and the case law, this damage should be covered, but at the very least, it is a question of fact to the jury of whether or not the policy, in tandem with Georgia case law, is a question of fact and shouldn't be one ruled on in motion for summary judgment.
Ms. Jackson,
yes.
Is there a dollar amount that's floating around yet for what the damages were with this soffit? Or is that something that no one ever got to assess?
I don't know that there's an individual line item for the soffit. I think it's the gigantic amount that you mentioned. Yeah, I can check and let the court know after the hearing, but.
No, that's okay. I mean, I know the 195,000 was not because of the soffit. The 195,000 was because the arbitrator concluded that there was poor workmanship and Mr. Kamara had to spend a lot of money getting another contractor to come in to fix the poor workmanship. Right. But in my mind, there was a wall built and it was at an angle and the contractor had to make the wall not at an angle. That's a made up example, but that's different from because of some poor workmanship, something fell and bashed this soffit that otherwise was okay. That was one of the few things that Mark Anthony Holmes got right. They did a great soffit on the garage, but then it was damaged because of something else Mark Anthony Holmes allegedly worked on poorly. So it's physical injury to tangible property. I follow you on that. I was just curious if there had already been an assessment that, yep, and it cost $911 to fix the soffit or what, because that seems to be the one area, although, and I'm going to ask Ms. Woodruck about this later, that Builders Insurance was saying maybe there is some liability for that soffit. And I just wanted to know how many decimal points we were talking about, how far from the zero we were with that.
Okay. And keep going, or did you want to?
Yeah, keep going.
Okay. All right. And second, Builders discusses our different claims in arbitration and how those are precluded by their policy. The two specifically, well, there's a breach of contract and the intentional tort claims. So on the breach of contract, the plaintiff argues that the policies don't cover contractual liability for economic loss. So essentially, just because we have a breach of contract claim, their policy doesn't cover it. However, our claims are based on, as you mentioned, defective workmanship and the resulting property damage. It just happened to be brought as a breach of contract and a tort claim. So the law in Jimenez, again, cited at the top of page 7 of our brief, says that a claim against an insured for defective workmanship on a construction project may be set forth as both a breach of contract claim and a tort claim. And the breach of contract claim alone, just the fact that it exists, should not preclude this commercial general liability coverage. And we also cite Glen Falls case at the top of page 8 of our brief, where, like this case, the underlying negligent workmanship is the reason for the breach of contract claim, and hence should not be precluded by the policy. And just same with those, with our previous argument, those two claims and the issue of whether or not the policy, if it's within the realm of the policy, is at least a question of fact for the jury, and we don't believe should be decided on a motion for summary judgment. Then there's the intentional tort claim from arbitration, where the plaintiff argues that the tort claims are not accidents that fall within the terms of the policy. They also discuss our punitive damages claim, which should not be covered because damage done to the defendant's home wasn't intentional. And I'd like to direct the court again to Jimenez, where the underlying claims were based on negligent construction. The plaintiff also makes an argument about attorney's fees, our claim for attorney's fees, and which are not covered, according to them, are not covered because the expenses don't arise from property damage. But again, and as the court mentioned at the beginning, we won on those claims in arbitration, breach of contract and negligent workmanship claims, and the expense for those at the least presents a question that should be presented to a jury. And as mentioned before, the property damage caused by an occurrence is phrase that sort of appears in, in both of our briefs in their policy. I'd like to point the court to Taylor Morrison Services, where for an occurrence to exist, the claims must be something other than fraud. The claims brought must be claims other than fraud. And we did exactly that in arbitration, where Mr. Kamara asserted both breach of contract and negligent construction, both arising from Mark Anthony Holmes and Mark Ferguson's negligent construction. So, I mean, the very extent of the coverage is a question of fact and not, and regarding whether the property damage was in fact caused by negligence. And the next argument is the exclusion argument that plaintiff makes, where we get into public policy. So I don't know if you want to, it sounded like you wanted me to kind of touch on that first and then go back to.
No, you go in the order you want. I guess what I'd like to do, and it may be that Ms. Woodrick is going to do this, is if we could get into the language of the insurance policy, because here's how I have distilled, and it helps me to make things as simple as possible. The way I've distilled the debate here is that Builders Insurance is saying that Mr. Kamara recovered from the arbitrator because the arbitrator found that Mark Anthony Holmes did a bad job. That's my phrase, did a bad job, but negligent construction, et cetera, et cetera. Whether you call that a tort or a breach of contract, I don't think matters how you package it. It's ultimately, it was poor workmanship. They did a bad job. And Builders Insurance is saying, that's too bad for Mr. Kamara. We wished that these guys had done a good job, but our policy excludes coverage for doing a bad job. It covers a whole lot of other things, but if the ultimate reason why the insured is found liable is because he did a bad job, we don't cover that. That's what I think this boils down to. And we could go back and forth as to whether really you ought to have packaged your claim as a breach of contract or a tort. I don't know that that matters, because if doing a bad job was covered, doesn't matter if you sue as a tort or a breach of contract, the action of doing a bad job was covered. So what I'd like to do at some point, whether it's through your presentation, Ms. Jackson, or Ms. Woodrick's, let's get to the language in the insurance policy that effectively says, we, Builders Insurance, are not liable if what you get in trouble for is doing a bad job. I'm sure that's not what the language says, but that's sort of how I've distilled it. So if you want to do that, Ms. Jackson, great. If that's going to be Ms. Woodrick, fine. But that just was my follow-up question. You gave a very good presentation of why you think there are things that ought to go to a fact finder, and why there ought to be more of a discussion about coverage applying here. In the end, I think the touchstone for all of us is, well, what does the policy say? And so we do need to look at that. And the policy is like 10,000 pages long. So it'd be helpful if someone says, hey, it's this page number right here. If you want to talk about public policy first, we can do that. But at some point, one of the two of you, I would like it if you would get us to where in the insurance policy, as opposed to public policy, the magic language is.
And Judge, if it's okay with you, I mean, it's builder's policy. I feel comfortable with letting Ms. Woodrick discuss that, and then if I can just respond.
Sure. Okay. So I'll let her do that later. Why don't you keep going with what you wanted to cover?
Okay. Sorry, flip my pages around here. So basically what the court was getting at, these different exclusion arguments. So the two that Builders points out in their brief are business risk and resulting damages coverage. And we, as the court was about to point out, we believe that those are contrary to public policy. The business risk in builder's insurance and builder's policy says is defined as any property damage arising out of work done directly or indirectly, and that's excluded. And the resulting damages coverage says it excludes coverage needed to make good any faulty or poor workmanship by the insured. So essentially, and you sort of touched on this at the beginning, it seems as if there's not a whole lot of things covered by the policy. And the plaintiff's reply, as we discussed, filed a couple days ago, says that business risk and resulting damage coverage exclude coverage for the purported soffit because the soffits are part of Mark Anthony Holmes' work on the Milton residence, or at the very least constitute products handled by Mark Anthony Holmes during the project. We believe that that's a factual conclusion within itself, and should not, again, be decided on a motion for summary judgment. In our brief, we talk about OCGA 1382B, which the plaintiff says doesn't apply here. However, the very language in 1382B says specifically a covenant in connection with or collateral to a contract or agreement relative to the construction of a building structure. So simply put, an agreement relative to the construction of a building or a building structure is exactly what builders policy is. So we believe that code section applies and should be considered in this matter. So I guess if you're going to allow me to respond, I'll wait a second to complete the rest of that.
Okay, I'll let you. I'm looking at 1382B now, since you brought that up again. So tell me why you think it's long, but the way I read it, it would be, the problem would be if Mr. Kamara had entered into a contract with Mark Anthony Holmes, and that contract had said that Mr. Kamara will hold harmless Mark Anthony Holmes if the work that Mark Anthony Holmes did was so negligent that it hurt someone else. But those aren't the parties to the insurance contract. Is builder's insurance contracting with Mark Anthony Holmes. It's not Mr. Kamara contracting with builder's insurance. So I'm not quite sure how 1382B applies, how that's something that Mr. Kamara can argue here.
Right. Well, I guess Mark Anthony Holmes is, builder's contract with Mark Anthony Holmes obviously directly affects Kamara, and especially in this matter where builder's insurance is saying that these damages don't fall under their policy. Well, Kamara is now required to, I guess, recover from builder's insurance. And so that is the association with 1382B. I understand the court's position, but
okay, I'll think about that more. Let me hear from Ms. Woodrick, and maybe she will get us to the language in the policy.
Okay.
Yes, Your Honor. I'm going to begin with the exclusions in the policy, as that seems to be the area where the court has some questions. And unfortunately, these policies do not have the most straightforward page numbers. So the page numbers are this is an exhibit to the complaint, exhibit B to the complaint. And the page numbers are a series of pairs of numbers or letters, which I can read to you if that is helpful.
I just need to know where to find it. So I'm
Yes.
I have a copy of your petition on the
Yes.
screen, and that's numbered in the sense that there are 367 pages of the petition, including the attachments. But I'm in the policy now, and you're right. It's not. It is not.
There, the pagination is not the picture of clarity. If you are if you're an insurance person, then maybe it is clearer to you. But if you work outside of policies, then perhaps not. If I may pull up on my computer screen, and then I'll find the page number for you.
Sure.
My apologies, I'm working with 2 computers currently. And I'm sure this looks strange. Okay. Alrighty, this is. I'll pull you off to the side. And also, if you will forgive my my delay with this computer system, it is new to me. It is new to all of us here at Swift Curry, and sometimes takes a little bit longer than I would prefer. Okay. The policy exclusions begin on page 93 of that document. The relevant exclusions that I would like to discuss, beginning with exclusion J, begins on page 96.
What I have on my screen is page 96 of the petition, says
Yes.
commercial general liability classification schedule.
Ooh, let me see. It might be a page or 2 off on ours.
This is, if you look on the screen now, that's page 96 of the petition.
Yes, there are some pages missing from my copy here. So it appears, let's see, you have 367 pages. I have 354 pages, which is not ideal. But it appears that it would appear on, if this is correct, page 110 or so.
All right, let's go down there.
Yeah, well, my apologies. Oh,
Looks like, yeah.
if
So
you
there's
will,
general liability, and then
yes, yes, that is where the exclusions start on page 107, and a few pages down from that begins.
So what's the section?
Section J, damage to property, which is on
is.
the bottom. That's correct.
Yeah, okay.
That is correct, Your Honor. And as you pointed out, this exclusion, the section that we are particularly interested in is actually on the next page, which is because this is property damage 2, and this is section 6 or paragraph 6 of the exclusion,
Okay.
which is property damage to that particular part of any property that must be restored, repaired, or replaced because of your work.
Okay.
And it is builder's position that as an initial matter, Mr. Kamara has, although we have the burden of proof on summary judgment, Mr. Kamara has the burden to show that his claims are covered under the policy, and he has pointed solely to the soffit damage as the property damage that was caused by an occurrence in this case. And the soffit, if it were damaged by the wall of the garage being installed improperly, would certainly be part of the property that must be restored because of MAH's work on the construction project. MAH was the general contractor. Its scope of work included the garage. It included the entire garage, including the soffits and the wall that allegedly caused this damage. So under the clear terms of the exclusion and the words here in the policy, that damage, the only damage that has been identified specifically in this case, would fall under that exclusion.
Okay. And then what exclusion addresses? So I'm hearing you. This is soffit,
Yes.
Small piece. What exclusion covers the rest of it, which is not that some part of the home that actually was built nicely was damaged, but all of the remedial work that the second contractor had to do?
Yes, and I think, Your Honor, that sub paragraph 6, particular part of any property that must be restored, repaired, or replaced because of your work,
Okay.
would additionally fall under that exclusion. Subparagraph 5, I think, would also work. That particular part of real property on which you or any contractors or subcontractors working directly or indirectly on your behalf are performing operations if the property damage arises out of those operations. So that would be the subparagraph directly above the one that has been highlighted by the court.
Okay. All right. And that is page 110. All right.
Yes, Your Honor. And my apologies about my incorrect, my confusing pagination in our brief in support of our motion for summary judgment, and my error in the pagination of the copy that I have. Like I
Not a
said,
problem. You got me to what I needed to see. Okay. Other things you want to argue on behalf of a finding that there is no coverage here for this particular set of damages?
Yes, Your Honor. Very quickly, I will not spend a lot of time on this, but just very briefly in addressing the intentional torts. Those claims had concerned an alleged misrepresentation by MAH and Ferguson regarding the completion of various tasks on the project and draws that were taken from the bank based on those representations. That is not only misrepresentation under Georgia law and the elements of the fraud tort in Georgia intentional, but it is also economic damage that is not related to these repairs. As far as the breach of contract claim is concerned, the language, and excuse me one second. The language in the demand for arbitration on the breach of contract claim, which is how Georgia courts determine a duty to defend, sought damages for breach in a certain amount, which was the difference between the contract price and the reasonable and necessary cost to have the claimant to have to complete the work in accordance with the terms of the contract. So there we are talking about getting Mr. Kamara getting the deal that he bargained for, more or less, which is exactly the kind of contractual claim that is not covered under a CGL policy. The soffit, as builders has acknowledged, and as the court seems to have pointed out, is a closer issue as to whether the negligence claim and that soffit, that one paragraph of the 131 in the demand for arbitration, constitutes property damage caused by an occurrence. And because the demand for arbitration alleges that the garage was constructed defectively in a number of respects, and that the soffit damage was a roofing construction defect. It cites a particular code section that deals with roofing. We believe that it's builders' position that even that allegation is not damage to non-defective property, as Georgia courts have found does not fall within the coverage of a standard CGL policy like this one. However, this court need not necessarily decide that close issue, because the exclusion J, and potentially other exclusions in the policy do apply to exclude that single paragraph, the only one that's been pointed out here, and the other paragraphs dealing with defects in construction from the coverage under the policy. As you pointed out, the language is very clear as to what is excluded there, and the definitions of your work and your product. All of those definitions are very clear. They're spelled out in the policy, and those exclusions clearly exclude this type of damage that comes from a general contractor's work. And the soffit damage and the other damage alleged in the demand for arbitration come from MAH's work. And in addition to that, Mr. Kamara has not alleged that the language is unambiguous or that the facts of this case don't fit that language. Instead, he has relied solely on these public policy arguments, which respectfully builders does not believe apply to this case. In particular, there were two public policy arguments raised in the briefing. And the first public policy concern dealt with the requirement to read a policy, an insurance policy, as a whole, and to apply all of its terms. And while the reservation of rights letter may not have included the entire policy, Mr. Kamara was not a party to that legal document and doesn't have standing to challenge its sufficiency in any event. But beyond that, the exclusions do not violate that public policy, because there's been no indication that the other terms of the policy are in some way in conflict with those exclusions. The entire, as we've noted today, the entire policy is woefully attached to the declaratory judgment petition in this case, much to the chagrin of many people who have to print things or upload things. And the parties have had a lot of time to look it over to determine whether that is an issue, and that has not been raised as an issue. With respect to the indemnification limitation statute, I think the issue does not really come with whether the policy is related to construction. The issue comes with whether the exclusions are indemnification provisions, which is what that section of the code addresses, and they simply are not. In fact, if you were to make some sort of analogy between an indemnification provision and an insurance policy, then exclusions would be the opposite of that, because the parties to the contract, the insurance company and the insurer, the insurance company would say, we are not going to pay for that, as opposed to saying we are going to pay for that if it's your sole negligence. And that indemnification provision says that the person who committed all the negligence is going to get paid and get defended. And the exclusion says the person who committed all that negligence is not going to get paid and is not going to get defended. So it's actually quite the opposite of that. And so we do not think that this is an apparent public policy that is violated by these exclusions. And therefore, the court should apply these exclusions as they are written, as their clear terms have laid out, and that is to exclude Mr. Kamara's claims under the policy.
Okay. It does seem like on the policy side, the public policy side, there is, of course, a remedy for Mr. Kamara in this situation, and that is to do exactly what he did. He took Mark Anthony Holmes and Mr. Ferguson to arbitration, and that arbitrator found, Mark Anthony Holmes, there are a bunch of things that you did that were negligent or not consistent with the terms of the construction contract you entered into with Mr. Kamara, and you're liable to the tune of $300,000. So there's certainly a remedy out there, and what Builders Insurance has decided is we're not going to cover someone who ends up owing an aggrieved party simply because they were negligent in doing their job. So I think I understand that. Ms. Jackson, I promised you'd have a chance to follow up after Ms. Woodrick pulled us down into the depths of the document, which she
My
did.
apologies.
No, I asked you to do it. I all by myself have found the definitions. They're on page 204 of the 367 pages, but it's helpful to know what is meant by the different terms like property damage and your works and things like that. So I would like now to hear from you, Ms. Jackson, if you have anything you want to add.
Yeah, I just wanted to add just one more point now that we've kind of gotten into the language. And I've touched on this before, but I guess to just sort of conclude that property damage caused by an occurrence, builder's own policy defines that as that property damage as a physical injury to tangible property. And again, we talked about garage soffit specifically, and we believe that definition and that quote in itself is a factual argument. I mean, property damage, according to their policy, is tangible property. Tangible property, we believe, is that garage soffit specifically.
Yep.
That was pretty much. I just wanted to add that point about the language quoted.
Okay.
Ms. Woodrick, sorry.
No problem. Anything else?
Your Honor, I think that covers my arguments unless you have further questions or need a torturous tour through a terrible attachment to a complaint.
You needed to attach what you needed to attach.
That,
it just happens to
that
be
is
really,
correct.
really long. And the insurance I have in my very simple life is auto and homeowners. And so
That's
it's
right.
not a very thick document. This seems to be some bizarre, and I'm sure it's not bizarre to the practitioners of the trade, agglomeration of 97 different I guess there's a giant universe of aspects of a commercial general liability policy, and the insured is able to pick, I do want this, I need it for, there were things in here about nuclear waste. Hopefully poor Mr. Kamara didn't have to deal with that, but
Yes.
there are things that need to be included, and it ends up not necessarily looking real pretty from the outside. Okay.
And Judge, nothing
well,
from the defendant.
pardon me?
You just asked if we had anything additional.
Yep.
Just saying nothing from the defendant, just if you had any additional question.
So here's how we're going to do this. I'm going to spend a little time looking again at your briefs in light of what we talked about today. And either Ms. Niles and I will get to work on an order, or Ms. Niles will contact the two of you saying the judge has thought about it, and this is one that he's not going to have to wrestle with a whole lot. He thinks it's pretty clear. And side A, please draft a proposed order with the following outcome. That proposed order then would be sent back to Ms. Niles and the opposing side, so the opposing side could at least weigh in, not to say, I disagree with that. I get it, you guys disagree. Here's why we're litigating.
Sure.
But you know, if there was a typo or a factual mistake in there, the opposing side would have a chance to say, actually, I think that the dollar amount of the recovery through the arbitrator was 195,320, not 310, things like that. So it may be that we reach back to you all to submit a proposed order, but we may keep it in-house. We'll let you know one way or the other. If anything comes up between now and your next contact from us, just reach out to Ms. Niles and let her know. Anything else, Ms. Woodrick, for Builders Insurance?
Nothing additional except to say, if Mr. Kamara does have a concern about the ruling of the court binding Mr. Ferguson and MAH, I would like to reiterate that we are willing to reach out to him to get an affidavit or something notarized if that is a concern that needs to be addressed. And we can certainly address that outside of this hearing, but
right. I'm where I said I am on that, but you may want to reach out to Ms. Jackson and,
yes,
and address that with her. Ms. Jackson, anything else for Mr. Kamara?
Nothing, Judge.
All right, the two of you need to settle up with Ms. Elder so she doesn't have a sad weekend after she spent all this time taking this stuff down.
Yes, thank you.
But I wish you guys a healthy and safe weekend, and we'll be in touch.
Thank you.
Thank you, Judge.
Same
Have a
to you,
good weekend.
Judge.
All right, you two
Thank you,
take care.
Judge.